Okay, good morning, everyone. Welcome to the 7th Annual National Tour. This year's topic is Strangest Claims. Cue synthesizer music. As always, we have an exceptional lineup of forensic engineers and fire investigators. And today we're also joined by some wonderful lawyers from Harrison Pensa. We're going to be looking at some of the more atypical cases that we see. And I just want to go through a couple housekeeping notes. I'm really going to rush through these for the sake of time. We're going to be doing a live Q&A at the end of each webinar, so please feel free to submit your questions in the questions drop-down on your GoToWebinar control panel. We're going to try to get through as many as possible. If we don't get to your questions, we'll follow up via email. All questions will be addressed anonymously. Disclaimer, all information discussed in this webinar is for educational purposes only. It should not be applied directly to the administration of any particular file or claim. This webinar is being recorded, and we will be posting it on our website, LinkedIn, and YouTube pages, so please feel free to share them or reference them later. We will be sending everybody a completion certificate. We are tracking attendance, so if you're here for 2 sessions, you'll get a completion certificate for those 2 sessions. If you say for all 5, at the end of the webinar, you're going to get a prompt with a few questions about today's sessions, and we would love to get your feedback. If you're experiencing any technical difficulties, you can use the questions drop-down, or again, if that's not working for you, then please email webinar@origin-and-cause.com. Okay, let's get started. So for our first presentation, we're going to be looking at electrical claims. Our first presenter is Mazen Habash. Mazen is the president of Origin and Cause. He's also a designated consulting engineer. He has 38 years of industry experience and has performed over 3,500 forensic investigations, which include fire, product liability, and alarm system investigations. He's qualified as an expert witness in both civil and criminal courts in 4 Canadian provinces and in Massachusetts in the States. His technical specialties include fire investigation, electrical and electronic failures, product liability, alarm system analysis, and video forensics. Our second presenter for this session is Colin Campbell. Colin is a partner at Harrison Pensa and a practice group leader for the Insurance Defense and Subrogation Group. His practice focuses primarily on pursuing subrogated claims for insurance company. His work covers a variety of areas of the law, including negligence claims, product liability, professional negligence, fraud, and construction litigation. And I'm just going to pass things over to Mazen now. And Mazen, please take it away.
Well, good morning, everyone. I hope everyone is doing well. I wanted to thank you for joining us today. So I'm going to start. Before I start, I just wanted to also thank Colin for being my co-host on this. I really appreciate that he's taken the time to help us out. I think you'll find his presentation portion very interesting and very insightful. So let's get started. So part of our discussion today is going to be on bathroom exhaust fans and how they can be the cause of fires. And we're going to do a case study to demonstrate how bathroom exhaust fans can be the cause of fires. But before we do that, I thought I'd just go through and explain a little on the different ways that bathroom exhaust fans can be the causes of fires. So certainly bathroom exhaust fans can catch fires due to a variety of reasons. But it's important to keep in mind that such incidents are somewhat rare, but they certainly do happen, as we will see through our case study. So what are the potential causes of these kinds of fires from exhaust fans? Like any electrical appliance, exhaust fans can experience wiring problems, short circuits, and other electrical faults. Over time, wear and tear, just like any other piece of equipment, either on the wiring or connections, can lead to overheating and, in extreme cases, a fire. A motor in an exhaust fan is a critical and integral component of the fan itself. And if you can imagine, if it is not functioning properly, it can overheat and potentially ignite nearby combustibles. And you'll see from our case study that that is one of the main focus of some investigations that we did that we will show in the case study. Over time, dust and lint and other debris can also accumulate inside the fan housing or on the motor. Regular cleaning and maintenance are an important part of keeping exhaust fans in good working order. And I'm sure some of you can attest to this. If you're in your bathroom and you look up, sometimes you'll see dust accumulating around your exhaust fans. Now, neglecting this can lead to issues over time. So if not cleaned regularly, this buildup can cause the motor to overheat, as this dust can insulate the motor and reduce its ability to dissipate heat, creating that fire hazard. Now, sometimes, and not always, this accumulation of dust and debris can be combustible in nature, adding an element of fuel to the fire from the motor. In other words, just the mere fact that there is dust adds a fuel package to a possible failure in the motor, and this could allow the fire to propagate outside of the motor and fan housing. In other words, the accumulation of this dust can prevent the fire from remaining contained and limited to the fan housing itself. If your exhaust fan is not installed correctly, it may not properly ventilate the hot, humid air out of your bathroom, so the humidity from just taking a shower, for example. This can cause the motor to overheat and potentially lead to a fire. Now, if the ventilation ducts, for example, are too long or are restricted mechanically, this could cause the motor to overwork, possibly allowing it to overheat. And in some ways, this is similar to what we see with issues with dryer ducts that are restricted in airflow, or that the dryer ducting has several elbows or perhaps is too long. So all that means that the blower fan motor has to work extra to try and push the air through these long ducts or restricted ducts or anything of the sorts. So as we have issues with dryers, it's very similar to the issues that we would experience with improper ducting for exhaust fans. Some bathroom exhaust fans have built-in lights, and if the wrong type or wattage of bulb is used, that can generate excessive heat and potentially cause a fire. So it's important to make sure that if you have a light fixture in your fan, that the right kind of bulb is used. Like any appliance, exhaust fans have a lifespan. As they age, their components can degrade, increasing the likelihood of malfunctions or of electrical issues. This in particular with the operation of the fan motor. So this could impact the motor's bearings, causing the bearings and or the motor windings to overheat. Now a fan's lifespan is greatly impacted by how often it is used and for how long. Think of a fan in a main bathroom versus a fan in a bathroom that is hardly used. So both might have or be the same age, but drastically different in operational and maintenance or service history. So it's important to just not think of how old is the fan, but also how often is it used, and how long it stays on during a typical day. Manufacturing defects, while these are rare, there can be defects in the manufacturing process that may make a particular fan or model fan more prone to failures or overheating. And of course, we also have design deficiencies, and these could include insufficient or improper use of thermal protectors in some fans or fan motors that lead to age, wear and tear conditions on motor failures that then result in fire hazards. Now, ultimately, it's worth emphasizing that while these are potential causes, actual fires due to bathroom exhaust fans are not all too common, but they do happen. However, regular inspections, maintenance, and ensuring proper installation can greatly reduce the risk of such incidents. Making sure a squeaky bathroom exhaust fan is serviced or replaced is one sure way of reducing the risk of a fire. So again, going back to some of your bathrooms at home, if you hear a squeaky exhaust fan, you may want to have it looked at. So what we're going to do now is talk about a case study that shows these kinds of exhaust fans and how they can cause fires. Excuse me. So we're going to talk about a specific high-rise building, and what makes this an interesting or strange event is that this building had 3 different fires, March 13th, March 14th in 2014, and then on January 7th in 2017. So all the fires were in bathrooms of 3 different apartments. The fires were centered around bathroom exhaust fans. The scene examinations corroborated eyewitness information, which reported flames initially observed around ceiling of bathrooms within the building's apartments. After documenting the scenes, fire-damaged bathroom exhaust fans were secured for laboratory examinations. And we were lucky enough that we were able to find an exemplar fan, which was also removed from the site. Now, some of these examinations took place several months and even years later, once all interested parties were identified and notified. Some of the subsequent examinations were of exemplar apartments, bathrooms, and bathroom exhaust fans. As you can imagine, there was several floors in this building, several apartments on each floor. And at times when the apartments got vacant, we were able to go in there and take a look at the bathrooms, the setup, and look at these exemplar fans to help us understand what may be causing all these 3 fires that happened in 2014 and 2017. And eventually, at some point, the existing exhaust fans within the bathrooms of this apartment building were disconnected from electrical power and have subsequently been replaced throughout the building because of the fire hazard that we were able to identify. So after documenting the scene, fire damaged bathroom exhaust fans were secured. And like I said, examinations were taking place several months or even years after the first incidents took place. So here you're looking at 3 photographs, each one of a bathroom in one of the apartments. So the fires were certainly focused in those bathrooms. And the scene examinations, as well as eyewitness reports, confirmed fires in and around the bathroom exhaust fan. The fire damage was moderate, but smoke damage was heavy in all 3 apartments. Now, the 3 exhaust fans were of identical make and model and age, which was kind of interesting, but not unexpected considering that this was one apartment building. And of course, it sounds like they built a building and they installed the same kinds of equipment, bathroom exhaust fans in all of the apartments. In several of the apartments, of course, you had exhaust fans in the main bathroom as well as in the powder room. So fires clearly originating in the ceiling of the bathrooms. You can see these in the photographs. Again, 3 different apartments at 3 different times. Interestingly, that the ventilation ducts for these exhaust fans were assessed and documented. Again, this was done over several investigations or scene attendance. And this because part of the manufacturer's defense, arguing that perhaps the operation of the fans were impacted by the improper or ineffective ducting in the apartment building. And I think Colin will probably discuss a bit of this in the defense that the manufacturers of the fan and the fan motor brought forward during the litigation phase. During subsequent visits to the apartments, we also assessed the impact of dust and debris accumulation on the operation of these fans and fan motors. In some instances, there was also some of the fans that had been painted over. And again, as you can imagine, the manufacturers also pointed out to dust accumulation as well as the paint as part of their defense. suggesting that perhaps this impacted the operation of the fans and perhaps causing them to eventually fail and cause these fires. So in the photographs that you see now, we've got the fan assembly, the fan motor plus the squirrel cage blowers from the 3 different apartments. As you can tell, they look like they're fire damaged. All 3 look identical. Again, they're all the same make and model. A lot of them were heavily impacted by fire, leaving virtually no combustibles remaining. And in those 3 cases, of course, you can't see any dust or debris because the dust or debris is either burnt off or perhaps during fire suppression activities, the hose stream might have gotten rid of that kind of accumulation. But we were able to see some dust and debris on subsequent fan examinations of an exemplar nature. So again, you can see fire damage was clear and all 3 exhaust fan remains. These fans were examined in our lab in the presence of the manufacturers of fans and the fan motors. The fan controls and wiring was examined as well, although I'm not showing them in any of these photographs. And then the fan motors were examined and then they were taken apart and disassembled. So these fan motors were 2-speed motors with squirrel cage blowers. And they were thermally protected, which is quite interesting and important, the fact that they were thermally protected and yet we had fires happening. The motors were very small in horsepower, and based on this 2-speed motor feature, they either drew 0.6 amps or 1.4 amps, again, respectively at low speed and high speed. And the reason that's important to us is it basically tells us that the motors certainly are not considered a high load on the electrical services of the building or the apartment of the bathroom. In other words, they're fan motors, but they weren't anything that would really tax the electrical wiring on the building. So once we got to the stage where now we're examining each of these fire damaged motors, and these were done consecutively in the presence of the manufacturers, we were able to open up the end cap for these motors so that we can look at several things. Number 1 is the windings for the motor. We wanted to make sure we considered what the condition of each of these windings are. We also looked at the bearings because that's part of the mechanical portion of the motor and is an important part in any examination or inspection to identify whether there is evidence of the bearings seizing up mechanically. And we also wanted to look for the thermal protectors and assess whether they operated or not. So the photographs that you're looking at are of 3 different motors from these apartments. And if you look at the yellow arrows, you'll see evidence of electrical melting of the windings, resolidified copper beads. So these were clearly fire damaged, and there is evidence of electrical failures, which we discovered when we looked at the windings, consistent with the motors overheating while in use. And again, those yellow arrows really point towards evidence of those failures. Evidence of electrical failures were discovered on the motor windings consistent with the motors overheating while in use. So you can note that there is beads of resolidified copper on the windings. Again, to an investigator or a fire investigator, an electrical engineer, this is suggestive of an electrical failure on the motor windings due to long-term overheating. Now, these 3 fires were confirmed to be due to a fan motor's overheating and igniting combustibles, including the insulation material on the motor windings, combustibles within the fan assemblies, and possibly other accumulated debris that was of a combustible nature, such as dust. It is most likely that these 3 fan motors were at their end of life, eventually reaching a state of locked rotor or almost locked rotor condition. Now, motors in a locked rotor condition are effectively energized but have a mechanical or electrical impediment preventing the motor rotor or shaft from turning. An example of this would be if the bearings have gone bad and they're seized up. No matter how often you try to energize the motor, it just can't turn because the bearings aren't in good condition. Now, when a motor remains energized, but for some reason it can't turn as it should, the motor draws more current than expected, and this can result in the motor windings heating up. So this is one of the reasons why motors have thermal protectors. Now, in the case of these 3 apartment fires, the 3 fan motors, although thermally protected, clearly the thermal protection was not entirely effective in preventing the motors from failing, igniting, and causing these fires. And now I'm going to hand it off to Colin.
Thanks, Mazen. I appreciate that. I hope I did the screen switch over properly, but I appreciate being here. I've attended this conference, so to speak, for many years, and this is the first time I've had a chance to present. This is an interesting case study because this case went on for several years. It was great working with Mazen. Believe it or not, I've had a number of these bathroom ceiling fan fires over the years. So while it's rare, there's something to be said for the fact that our firm gets a lot of these through the door. I'm going to give you sort of a high-level overview from a litigation perspective with respect to this case study. So as is not uncommon, our firm was retained almost 2 years to the day after the first 2 fires. Now, let's say we had an extra month, but the file comes in, a lot of work has already happened at the adjuster level. Fortunately, on this case, a lot of good work had happened. Mazen had already been involved. We had instructions to issue a subrogated claim against the manufacturer of the fan and of the associated motor within the fan for the first 2 fires, and we did that. Not much happened thereafter for the first year or so. Claims had to be served. Both parties, both defendants rather, are large US-based entities. So it's not easy to drive the bus super quick, especially when you start with American counsel. Less than a year after we issued our subrogated claim, a 3rd fire happened in the same building. Different unit, same sort of fan. We were able to issue another statement of claim for the 3rd fire. So 3 fires, 2 subrogated claims. And not long after we issued our 2nd subrogated claim, our insured, so our insured is the owner of this apartment complex, was named in a lawsuit brought by the insurance company for the tenants. So the tenants in the apartment for the 3rd fire, there were students, they had lots of contents damages. Their insurance company subrogated and issued a claim against the same defendants that we had named, the fan manufacturer, the motor manufacturer, but they also named our insured, right? And the reason they did that is they wanted to say that you guys knew enough that there was a problem with the fans after 2 consecutive fires a day apart, and you didn't really do enough to investigate or prevent this 3rd fire, so you got some exposure. So interestingly, the defense of that claim, those 2 claims, there was a subrogated claim and an uninsured claim for the 2 tenants, was referred to us. And so Harrison Pensa had 2 separate hats on. We were subrogation counsel, plaintiff's counsel, in 2 actions for 3 fires, and we were defense counsel in 2 actions for 1 fire. As you can imagine, that's a lot of claims, it's a lot of lawyers but it's also a lot of overlap. So there was consolidation. Actions were joined, merged together, and that took some time for everyone to get their ducks in a row. What we do at Harrison Pensa when we jump in is we start working right away with the expert. In this case, we had origin and cause, and we had Mazen retained, and he was off to the races. Some site examinations had already happened, some parts testing had already happened by the time we were involved. Destructive testing had happened almost a year after the third fire. Reports were prepared. We had preliminary reports from Mazen, and ultimately final reports or summary reports. We worked with the insurer to gather as much information from them as possible. We knew that there would be a lot of disclosure obligations in this case, so we were very careful to request as much as we could and to sift through it from our insured. There were lots of challenges in that respect, which I'll touch on shortly. There was also an uninsured loss that we rolled into our third claim for the third fire. So after the third fire, what our insured did is they went out and they replaced almost every fan in the building. And that was at a serious cost, and they asked us to include that as an uninsured loss, and we are obligated to do so. And the argument being that this replacement, this cost, is necessary because there is something inherently wrong. There's a defect, there's a problem with these fans, right? And so we are now mitigating following the third fire. And so that was just an interesting piece here. We put together our documents, we put together a subrogation package. In this case, it was quite large. We had damages from 3 fires. So the quantum across all 3 was quite high. We surveyed on everybody. We sent Mazen's reports out because we didn't want to sit on those any longer. And what we did, along with plaintiff's counsel for the tenants, is we sort of canvassed the group to take a more practical approach. A lot of parties involved. We could all blow our brains out, so to speak, on legal costs and working the file up for several years, or we could take a practical approach. Someone is responsible for the fact that these fans sometimes spontaneously would ignite, particularly in this building. Engineers have and will come up with a probable explanation, which will likely be accepted by a trier of fact. We had produced Mazen's findings about the motor failure. Nothing else had been produced from anyone else at that point. We acknowledged that someone would also be responsible to some extent for the third fire, and that steps were not taken or recommendations were not made after there was a known risk or a foreseeable risk. But let's mediate this, right? The damages are in order. This would be a perfect candidate for a pre-discovery mediation. Spoiler alert, that didn't happen. What did happen were, what followed was several years, it felt like, of contentious litigation. Again, as I said, the document disclosure was quite significant. I'm talking piles upon piles of documents. I think we had 3 large volumes of affidavits of documents that we served, and we received supplemental requests from the defendants. So they sifted through our stuff and they were not satisfied and they wanted more. We had served everything we had, but we have an obligation to chase for this stuff. So the firm rather spent 18 months trying to get to discoveries because the defendants would not agree to proceeding to discoveries unless they had everything they had asked for. So we bent over backwards to try to get them that. And I'm talking about as-built plans for the building, mechanical drawings, electrical drawings, who did the installation of the fans, the ductwork. No stone was unturned. And what the defendants had intimated, or rather expressed quite clearly, was this isn't us, this is going to be an installation defect. Someone screwed up when these fans were installed. They didn't follow our directions. It's going to be their fault. We'll have to pull them in. And so we understood the scorched earth approach. I felt like it was fishing to some extent, but we tried to go along to get along and to be as cooperative as possible. The defendants took sort of a joint approach to this. There were 2 separate counsel, 2 separate insurers, but they worked hand in glove, and they would write to us Often there was a letter that came in saying whatever this defendant says goes for us, and vice versa from here on out. But the litigation was a little bit contentious. By the time we got to discoveries, there was a dispute over who we would produce as a witness. The challenge with this one is that everyone who had been involved with the construction of these buildings, the installation of the fans, was long gone. And there was a lot of turnover in terms of ownership of our insured company and the site super, the maintenance personnel. Everyone had come and gone several times over. So there was no perfect witness here. We ultimately did produce the current maintenance site department superintendent, supervisor, lovely man. He lived in the building with his wife. They had not started until about 2 months after the third fire, so he could not speak to practices prior to the 2 first fires or the third, nor could his wife, but he was our witness. The other side eventually accepted that. They're only entitled to 1 kick at the can and 1 witness. So we weren't going to roll over on that point. The fallout, however, was that we were buried in undertakings, and undertakings are the bane of any lawyer's existence. On this file, I can tell you they were close to 200. And again, part of our strategy here is we're as cooperative and helpful as possible because we want the defendants to write a check, in this case, a large check at the end of the day. Most of these requests for undertakings were perfectly fair. I don't know if they're proportional, but there wasn't a lot of room to refuse and to get bogged down in a bun fight. But we spent a significant amount of time post-discoveries trying to chase for answers, about who installed what, who inspected what. They want employment records for anyone who ever worked in the building. They wanted Mazen's complete file and any draft reports and any notes that he ever made and any pictures he ever took. Most of this is perfectly proper. More drawings, et cetera, et cetera. Finally made it over that hurdle. Again, we tried to mediate. There was no appetite, so we had to set the matter down for trial. We were at the 5-year mark. We set it down, and then the dispute or the procedural wrangling, as I say at the top of this slide, it continued, and we found ourselves before a judge several times to explain why certain undertakings couldn't be answered, what we had done to try to answer them. We papered our file, so every time I had to go try to chase an undertaking, I would write a letter to some company that may or may not exist anymore. I would follow up with emails, and I had to produce a lot of that to show the court that we had tried. We had made best efforts. This is not common to have to go to the wall on this stuff, but that was sort of the tone of this litigation from the beginning right until the end. Eventually, we made it over that hurdle, and the judge who had sat down with us at several case conferences eventually got fed up and said, I'm giving you a pre-trial date and a trial date as soon as possible thereafter. It's time to get on with it. So thankfully, that's where this went, and that's where the fun continued. So I mentioned that we had tried to mediate early on. As soon as we got the pre-trial set, the defendants came to us and said, why don't we mediate this? I mean, doesn't that make sense? Of course it does. So we did agree to mediate. We scheduled a mediation a month before the pre-trial. So that was good news for us. We had 2 kicks at the can. We'll try to mediate if that doesn't fail, or if that doesn't succeed. If it fails, we don't have to wait long before we can get before a judge and try again. A month before mediation, we also received, years later, the long-awaited responding investigative reports from the defendant's engineers. So these would have been the same people that attended the inspections with Mazen years before, that participated in the destructive testing. They finally ponied up 2 expert reports. One was on causation, and as you see here, the theory was no longer in installation deficiencies, but dust and lint buildup and some paint that was evident over one of the cages on top of one of the fans. It reduced the airflow. Motor could not cool. Lots of other things that they couldn't determine for sure But the lack of maintenance was the problem, and the dust and lint was the problem. It's not our fault, it's yours. We didn't have a lot of time, so as soon as those reports landed, I phoned Mazen, and I sent the reports to Mazen, and he went over them, and we decided that we didn't have enough time necessarily to prepare a responding report, at least not for mediation. But Mazen did give me some ammunition to push back in terms of our brief, what we put in our brief, and what we would say at the mediation. And if that failed, we could go to the pretrial and ask the judge for some time to file a responding report, which would have been perfectly reasonable. There was a second report produced, and that was just a standard of care report. And so that spoke to whose fault it was for the third fire. It was a very odd report, but it basically just said, your guys did such a poor job of maintaining these fans. They never inspected them. They never cleaned them ever. You fell below the standard of care of a reasonable property maintenance company or apartment management company or owner of such a building. Now, there was a shred of truth to that, and that was an area where we conceded a little bit when it came to settlement. But what I will say is that what was frustrating is that there was nothing necessarily in the investigative report that was new. So we had gone through years of document production and discoveries, and there was nothing in that report that was new that the defendants and their experts didn't already have years ago when Mazen's report was produced, right? So in some sense, we had gone through the rigmarole and the exercise of years of litigating and incurring significant costs for nothing, because the same arguments could have been made at a mediation pre-discoveries. Having said that, our insured witness was a lovely man, but the evidence that came out on discoveries was that this building did very little. It didn't respond well to noisy fans. Their resources were limited, and everyone did the best they could. It's not personal, but that evidence allowed them to come up with a standard of care report speaking to the third fire only. We did settle at mediation, thankfully, and our strategy in terms of pushing back against the new investigative report was, okay, well, you're trying to throw some shade on our conclusions, and we will acknowledge that there was dust and lint, and maybe dust and lint is combustible and it ignited, or it was the first material to ignite. Fine. But these, as Mazen indicated, these devices have thermal protectors, and they have thermal protectors for a reason, right? Because manufacturers anticipate these things will get dirty and hot. And so a thermal protector, if it works properly, is supposed to shut off the fan before it gets too hot and ignites. And so if these thermal protectors worked as they should have, an argument could be made, there would be no fires. So that was our punch back, so to speak. We could have formalized that and dug a bit deeper if we wanted to produce a responding report, but it was a coherent and cogent retort for the purposes of the mediation. And what I think also helped us reach a global settlement was we did concede a little bit on the third fire. So what our insured had done after the first two fires, right? And in hindsight is 2020. What our insured had done, again, limited resources, is they had sent around notices in this building saying, "We're so sorry about the inconvenience of these two fires, and we're going to go around and we're going to look at some of the bathroom ceiling fans in the building. And if you have any problems or have any issues or noises or concerns, let us know." It turns out they didn't really inspect all of the fans, and they didn't replace any of the fans, and it was sort of arguably a pithy response when they could have gone in there and done a little bit more. They could have inspected every fan. Perhaps they could have replaced them at that point. They didn't, but there was a reasonable argument that they knew or should have known that something was seriously wrong here. It didn't help that our insured had also been provided with a copy. This was before we were even involved. Here's some pencil, but I think they had been provided a copy or copies of Mazen's reports, right? So there was an argument that they knew or should have known, or they had an idea of what went wrong here. As I said earlier, by the time we were involved and by the time we got to discoveries and further, everyone who was ever employed at this building or with this company at the time of the fires was long gone, so there was no continuity there. We tried to ask them questions after the fact. What did you do when you first learned this, and did you ever contact the defendants to ask what you should do? There were no good answers to any of that. But we did concede on the third fire that we had some exposure. So it was a good result for our insurer client. 3 fires, 3 separate losses, a recovery in all 3. But what I think helped facilitate this was that there was also a contribution to the tenant's claims in the third fire. So one could call it a set-off. It wasn't really a set-off, but the defendants paid out on all claims, and a contribution was made by the insurer, our insurer, on the third claim, acknowledging some exposure there. And again, the responding report produced by the defendants in advance of mediation, it served its purpose, right? We had to address the fact that they now had an expert report. We didn't accept its findings or conclusions, but if they had showed up at that mediation with nothing, it may have been a better result, but it likely wouldn't have settled either. Looking back on this case, after so many years and after the PTSD has passed, so to speak, just some thoughts I've had is witness statements and witnesses. So I'll talk on some other tips on my next and final slide, but it would have been helpful if we had witness statements immediately after the loss. Now, there was a paragraph statement from the property manager, literally a paragraph long, that was buried in the file that we can never find her, but statements from the super who responded, and from tenants and from management would have been quite helpful. We always ask for more pictures, and maybe just a list of witnesses, people and their addresses that we can contact down the road, so it will save us chasing them years later. Record collection. Again, by the time Harrison Pensa was involved, when we contacted our insured and said, this is who we are, we're going to subrogate, can you look through your records? They had thrown out a lot of records. They didn't have a lot. So it would have been helpful to sort of gather that up front or set expectations early with the insured. Photographs are helpful. We had some. Madison's always very good at taking thousands of pictures, which ultimately make their way to us, and we pass them along, which is great whenever he's in a unit or doing his testing. And it's hard, again, with hindsight, but more consideration perhaps against future losses here. It's hard to know, even after 2 fires, which may or may not be a coincidence, whether it's going to happen again in the future. Case management would have been smart early on. We didn't necessarily get bogged down, but every box you have to check in litigation when you go the distance, we had to check. It would have been helpful to sort of request case management right away, so we had a single judge who could help us shepherd this along and maybe deal with some of these undertakings requests in a more timely fashion. I just wanted to talk about this argument about the replacement of the fans and that uninsured loss, because I find it interesting, and I'm seeing it more and more. And another example I have is a sprinkler bursting in a large condominium in Toronto. Sizable loss, water damage. Our expert opinion is that there's a manufacturing defect with this sprinkler, right? There's an inherent defect. Fortunately, we have the benefit of some class actions having already occurred in the United States with this type of sprinkler. Our insured wants to replace every sprinkler in the building. There's hundreds. The cost to do so will be hundreds of thousands of dollars. And what they're wrestling with now is can and should they do that, and then roll that in as an uninsured loss? And there's no easy answer. We're not the ones to provide a professional legal opinion on that, but what you would need to succeed on that is you would need a real solid opinion. You would need good proof beyond a reasonable doubt that this sprinkler, this veranda sprinkler, has a manufacturing defect and is prone to failure, but that the likelihood of future failures in this building with this part are extremely high. You would need those 2 things in hand before you ever went and replaced anything else. So we didn't necessarily have that in this case, but we did recover on that third claim, and we recovered a portion of the insured's uninsured loss on the strength of Mazen's reporting. So that's sort of the litigation side of this, I suppose, case study. I sort of always finish my mini presentations with a couple tips. I'll be short on this. Identifying targets. In this case, consideration was made as to who are the defendants up front. It was pretty clear that we needed the manufacturer of the fan and the associated components. We didn't have anything to suggest there was an installation issue, a wiring issue, a ducting issue. We didn't need the installer. But when you're looking at a file, we say cast a wide net. And I'm not saying sue everyone just to be safe or just because, but we say look beyond the most obvious target, right? Is there a sale of goods act that can be made? Did someone sell these? Did someone resale these? Did someone service the fans? In our case, we didn't have a service provider. No one came in and cleaned these things, otherwise they would have been a party. For fire losses, especially at homes, or if there's a rekindling, could the fire department itself be liable, right? They're supposed to do a number of things to set up a fire watch, ensure that they've doused a fire completely. If there's a rekindle, and again, I've got several of these where there are multiple rekindles, and it's the third or fourth rekindle that causes the house to burn down, right? So in addition to who's responsible for the initial fire, who's responsible for the rekindle might be more important. In apartment fires or large condominiums, was the security response adequate? Did the fire suppression system work properly or at all? We just want to think outside the box and remember that it's not always a balance of probabilities that we need to meet, right? Ideally, that's where we want to get, but we're in the business here of establishing risk, right? So even if we can't meet or exceed 51% on a party, or if they're not a target or the primary defendant, if we can establish some risk, that may help us leverage a settlement or a contribution from them down the road, right? We're in the risk business. Notice is super important. In this case, notice was made by our insurer and the adjusters, and got everyone involved early on. I'm seeing a lot of cases where the targets or the defendants would be American companies. They give us a lot of grief if they don't have notice immediately, such that they can send someone up to inspect the scene of the fire. Again, if you're suing a municipality, there's certain obligations there. Spoliation doesn't normally arise. It's a very hard case to make. There has to be some intention, but we want to be very careful with the evidence, that we preserve it, we don't touch it. There's a chain of custody, pictures everywhere, all over the place. Again, statements document the scene, because a spoliation argument just gets you bogged down and it's a distraction and it takes time and money to deal with. And the last thing that I think is relevant here is dealing with experts. So, while we see the same experts a lot, I've worked with Mazen a handful of times over the years. It's sort of an arm's length relationship. The expert is his obligation, his or her obligation is to the court. Yes, they are retained by us or our insurer client, but we're always careful when dealing with experts. And what I say is always develop a relationship where you can speak with your expert verbally first, right? Always have a conversation to the extent possible. I know email is easy and preferred because we're all getting too many messages on a daily basis, but an extra 5 or 10 minutes to talk to an expert and hear what he has to say or what he could say before putting it in writing helps. Draft reports always before a final report. I always like to ask the expert I'm working with, what could you say? Could you say this? And if you couldn't say this, what would you need to be able to say this? Again, we're trying to get to more probable than not, right? Probable over possible. Possible is not great. We can deal with it. More likely than not is important. And just keep in mind that if you ever serve a final expert report or a summary report, and the defense really wants it, they can probably get every single draft or email produced. Again, that's why we're also careful as well and prefer to speak to our experts verbally. And Mazen, I don't know, that's sort of the last thing I have to say about that. I don't know if you have anything to add about how difficult and unpleasant it is dealing with lawyers, but hopefully not.
Wow. How much time do I have? Now, all kidding aside, I like from my vantage point and my experience in many of these past claims, I think there's a lot of value in bringing lawyers in early on or at the front end of a claim. And I just find that, if they come in quite late, I think it takes them a lot longer to catch up. So if they come in early on in the claim, I think they have a better understanding and a better handling on just the claim in general. So, I would always recommend that lawyers be brought in early on, specifically when you know that this is going to go down the route of subrogation or some form of litigation.
Yeah, Mazen, I would agree. On some cases, the file will land with us almost 2 years later, and there's a report and everything's done and dusted. In other cases, we are brought in early, and it's good to be able to work with the expert, not hand in glove, but we're both sort of participating and investigating the claim together at the same time. I do think it's helpful, but I don't know if there's questions here or how to work that, Mark.
Yeah, no, I will. So yeah, this is the time where we're going to be taking questions. We've got one in already, but if anybody else has a question for either Colin or Mazen, please, it's just the questions drop down in your control panel there. You can go ahead and submit. So the first one here is for Mazen, and the question is, could you please expand on how the melted copper balls develop and are a sign of overheating?
Okay, that's a good question. So if you recall, one of the things I was talking about is when a motor starts to labor because of some kind of an impediment. Let's say it's a mechanical issue, end of life, and the bearings are starting to seize up. There is excess current that's being drawn through the windings, which means that now the windings start to heat up, overheat. And there's a stage where if the thermal protector isn't properly configured, if it's not at the right location, maybe it's not at the right temperature, the insulation on the windings start to degrade, undergo pyrolysis, and eventually the ignition temperature of that insulation starts to diminish. And at some point, the motor runs hot enough that material can ignite. And to get that ignition, what it means is that the insulation is degraded. Now the windings could fail electrically. And when they fail electrically, they exhibit melting, which manifests itself physically in terms of these resolidified copper beads. So it's effectively when you hear some experts talk about electrical arcing failures, that's exactly what those copper beads are showing. Electrical arcing failures on the windings because the windings have overheated.
Okay, fantastic. I've got two here regarding the lifetime of an exhaust fan. So how old were the exhaust fans that caused the fire, and is there a generally accepted lifespan for exhaust fans?
I think Colin and I were discussing this the other day, if we knew how old these fans are. And Colin, I don't know if we ever figured that out generally. But the point is not to focus on necessarily how old they are, because think about it this way. You can have a 10-year-old fan that's operated, let's say, 12 hours a day. Or you can have a 12-year-old fan that's operated 1 hour a day. So there's a big difference in the lifespan of the two fans, not because of their age or when they were manufactured, but how often they're used. And therefore, it's not just a question of age, but also use.
Yeah, I can add that the building, I believe, was approximately 10 years old. Some fans had been replaced within the building because they were noisy or they rattled. I don't think our 3 incident fans had been replaced, but this was an issue on discoveries, and we asked the defendants, well, what is your end of life? What's the date? We didn't get a definitive answer. And if there was a date, do you advise end users? Is it on the box? What do you tell them to, what do you tell them to do? And is a fan, when it reaches the end of life, supposed to spontaneously combust? Is that what we should expect? We didn't get the answer we wanted, but those were the questions we asked. So that's sort of how we dealt with that.
And I would maybe jump in and add to what Colin said. I think the expectation is that every mechanical electrical device does have an end of life at some point, but you would expect that manufacturers would foresee some of these issues and would build in sufficient protection into the device such that when the end of life is reached, it is done in a safe manner. In other words, rather than start a fire, the end of life means that the thermal protector would kick in and interrupt power to the fan so that it can no longer overheat.
Okay, I think that's great. I think that that really covered it. So I think this one, I guess, Mazen, you're probably gonna have to kind of search back in your memory here. Do you know if any circuit breakers tripped?
Good question. I think what we found is yes, circuit breakers did trip, at least on 2 out of the 3 fans, but not necessarily the 3rd fan. And again, remember when I was talking about how many amps are drawn because of the kind of motor that's there. So in some instances, we would expect some trip breakers because of the failures, but that's not a necessity. So in other words, if we don't find the circuit breaker having tripped, it doesn't negate the fact that these fans did sustain failures internally and did cause the fire.
Okay, fantastic. Kind of 3 I'm going to kind of bundle together. So can you say who the manufacturer of the fan was, and has any recall gone out regarding that product?
Yeah, I'll jump in. I can't say who the manufacturer was or is. Obviously, there was a settlement here. Can't disclose that. To the best of our knowledge, there is no recall. Was no recall. Would have been quite helpful if there was, or if there was some sort of class action in the States, similar to the sprinkler file I'm dealing with at the moment. But nothing to our knowledge.
Okay. Another one for Colin. Could you have held the renter of the apartment liable? Was there anything signed by the tenant saying that they were responsible for cleaning and maintaining the apartment?
It's a good one. The lease for the tenant was a page and a half long. Might have well have been on a napkin. There was no angle there, right? It was not their responsibility to clean it. Our insured acknowledged that they were responsible for the maintenance of these specific components, and they'd hired a company to vacuum the ducts that lead from the top of the fan outside. They did that once or twice over 10 years. And again, they responded to any complaints about noise or rattling, but there was no onus on these 2 students to do any maintenance with the fan. And I think they had only been in there for a few months. There was some talk about,
Sorry. Would that change from a rented apartment to, let's say, a condo building where somebody owns the unit?
Yeah, it might. It might change the analysis. I'm just trying to think. I mean, if we were onto the condo corporation, right, and we were asked to subrogate, we would most likely not be able to subrogate against the condo owner. And if we were on for the condo owner trying to subrogate against the fan manufacturer or the component manufacturer, we would have to rebut the defense that says this is all your fault because you were the one that didn't clean this, and you should have known, and did you buy it? And did you look at the box? And all sorts of those same arguments.
Okay, that is that takes us to 11:30. I think we got through all the questions. If anyone else comes up with any questions, please feel free to submit them. And actually, sorry, one just came in. Let's just try and get through this. Although this could precipitate something. If the cause is overheating, does the fan need to be running at the time of ignition? That would be a Mazen question.
Yes. So at the time of the failure, which then caused the fire, the fan would have had to be running at the time of that failure. Yes.
Okay, fantastic. And so that takes us to the end of our first session. We're going to take a 10-minute break, which is probably enough time for everybody to go and look at their bathroom fans. And then we're going to be back with two of our materials engineers, Eduardo and Dinu, and they have a real variety of interesting case studies that they're going to take us through. Okay, so we'll see everybody back at 11:40. And thank you so much to Colin and Mazen.
Thank you.
Thanks, everybody. Thank you.
Take care, everyone. Bye-bye.